Now, in the remaining time, I'd like to give each of you a minute, maybe 90 seconds, to give us a summation, really, of the key takeaways that you'd like the audience to remember from your segment. We're going to do it in the order of presentation. So we're going to start with you, Greg Smith. Some key takeaways, please.
Okay. I would just like to reiterate that the principles for IP damages are very similar to the principles for damages generally in commercial litigation, particularly with respect to lost profits. Reasonable royalties, while still compensatory, are more specific to IP matters. And I would point out, and I think Robert alluded to this earlier, there is a lot of activity at the Federal Circuit every year, and there are several decisions every year that have implications for how you calculate a reasonable royalty, so it's important to stay current on that. And then lastly, I would say that within the categories of intellectual property, the principles of damages calculations are very similar, but there are some differences in each case that you need to be aware of when you're formulating a claim or rebutting a claim.
Thank you, Greg Smith. Robert Vigil, a minute to 90 seconds for some key takeaways.
Yeah, I think what I would like people to take away from the presentation would be at least three things. First, apportionment is not new. It's just more difficult to do. I think the requirement's been around for a long time. We know that. But as anyone who's been involved in the business will attest, doing it is increasingly difficult given the nature of the products, given the amount of technology. It's harder to do. For lost profits, a thorough PANDU analysis is all you really need to do for apportionment, assuming that you're doing a thorough analysis of both the PANDU factor 1 and PANDU factor 2. I think you're covered and don't need any further apportionment. And the third point would be for reasonable royalties, there are lots of different ways to think about apportionment. There's lots of different ways to do apportionment. Which method is the most appropriate depends on your situation. It depends on the availability of data, depends on the amount of money that you have to work with, and the amount of time that you have, but all else equal, more methods that can be used for apportionment, the better.
And thank you, Mr. Vigil. Eric Forrester, your turn. Some key takeaways.
Sure. Keeping in mind that the damages calculation is using a method that can be subject to criticism, that relies on data that can be subject to criticism, and the application of the method to the data and facts of the case can be open to criticism. We'd really want to hone in on making sure you understand the comparison that's at the heart of your expert's damage calculation, ask about it, understand it. In particular, understand how it fits into the rest of the steps of the damage calculation. And then another key takeaway is beware potential contradictions between the methodology that's being used and the facts of the case. In particular, if one says downplaying a piece of evidence on the liability side, make sure that that's not a key part of your damages expert's analysis. Thank you.
And thank you, Eric Forrester. Finally, Armando Chavez, some key takeaways from you, sir.
Okay, as far as key takeaways from the cases I discussed today, I think we've covered apportionment in the Mentor Graphics case fairly well, and how that essentially shows that the value of the patent, the claims are tied basically to the damages when you use the PANDUA test. So moving to the second patent case, Xmark, that I discussed, what I would take away from that is the essential requirement is that the royalty be based on the incremental value that the patented invention adds to the end product, and that the reasonable royalty must sufficiently tie to the facts of the case in terms of how it was calculated. And there must be proof of damages on the claimed invention's footprint in the market. And so long as the expert in that case apportions between the improved and conventional features of the accused mower, using the accused mower as the royalty base and apportioning through the royalty rate was an acceptable methodology in that case, based on facts in that case. And as to the concluding section regarding damages under the Lanham Act, I would just highlight that the objective is to determine damages that are tied to particular facts and circumstances of the case. And ultimately, the law dictates what monetary relief is available for a particular action brought by the plaintiff. And depending on the evidence, there could be a variety of injuries, such as lost profits, corrective advertising, royalties, and defendants' profits would also come into play. So particularly in IP cases, as with other cases, it's important to note that each case is fact-specific and that the appropriate methodology can vary based on the case-by-case basis depending on the facts and circumstances. So it's important to tie your damages claims to the evidence as well as to the law that's in effect for the particular jurisdiction. Thank you very much.